Start. Para. The trial court, after appreciating the oral as well as the documentary evidence adduced by the prosecution, held that the prosecution had proved the charges levelled against the appellant accused beyond reasonable doubt. Accordingly, the appellant was convicted and sentenced as stated herein above. In the appeal preferred by the appellant before the High Court against the said judgment of conviction and sentence, the High Court reappreciated the evidence on record and confirmed the conviction and sentence recorded by the trial court. Para. The learned counsel for the appellant vehemently submitted that both the courts had committed gross error of law in misappreciating evidence on record and in holding the appellant guilty of the alleged charges, though the prosecution had miserably failed to prove the demand of illegal gratification allegedly made by the appellant, placing reliance on the decision of this court in the case of Jairaj versus State of Andhra Pradesh. He submitted that it was required to be proved by the prosecutor beyond reasonable doubt that the accused had voluntarily accepted the money knowing it to be a bribe, and in absence of proof of demand for illegal gratification, presumption under section 20 could not be drawn against the accused. According to him, in the instant case, the complainant having expired before the commencement of trial could not be examined, and hence the very allegation of demand of money as bribe was not proved by the prosecution. The learned counsel for the appellant placed reliance on the statement of complainant recorded before the additional first-class magistrate under section 164 of CRPC to submit that the complainant himself had stated therein that he had paid the amount to the accused towards the audit fees of the society, and that the accused was falsely implicated by the former president of the society who had a grudge against the accused. Para. In our opinion, there is no substance in any of the submissions made by the learned counsel for the appellant. It is well settled proposition of law that the death of the complainant or non-availability of the complainant at the time of trial could be not said to be fatal to the case of prosecution, nor could it be said to be a ground to acquit the accused. It is always open for the prosecution to prove the contents of the complaint and other fact in issue by leading other oral or documentary evidence in case of death of or non-availability of the complainant. In the instant case, the appellant in his explanation under section 313 had accepted the receipt of alleged amount. The court therefore was required to appreciate the evidence laid by the prosecution in the light of the said explanation and to consider as to whether the said amount was an illegal gratification other than the legal remuneration or not. It cannot be gainsaid that if the accused offers reasonable and probable explanation based on the evidence that the money was accepted by him other than as illegal gratification, the benefit of doubt should be granted to the accused. It is also true that the accused is not required to establish his defense beyond reasonable doubt as the prosecution, and can establish the same on the preponderance of probability. However, the court cannot be oblivious to the statutory presumption permissible to be raised under section 20 of IPC Act with regard to the motive of the accused. Section 20 reads as under. Presumption where public servant accepts any undue advantage where in any trial of an offence punishable under section 7 or under section 11 it is proved that a public servant accused of an offence has accepted or obtained or attempted to obtain for himself or for any other person any undue advantage from any person, it shall be presumed unless the contrary is proved that he accepted or obtained or attempted to obtain that undue advantage as a motive or reward under section 7 for performing or to cause performance of a public duty improperly or dishonestly either by himself or by another public servant, or as the case may be, any undue advantage without consideration or for a consideration which he knows to be inadequate under section 11. Stop.